Citizens' arrests in Canada. What's allowed, what's not allowed, how do you do it, should you do it? These are the things that I'm going to discuss on today's episode of Don't Talk TV. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Citizens' arrests are something that you don't see very often. They're also something with a lot of considerations, legal and practical, around them. And a viewer was asking me about them. I thought it was important to do a video giving a summary on Canadian law as regards to citizens' arrests. There is allowance in Canadian law for citizens to make arrests, but there are some very specific requirements that I want to go over. To start with a little bit of history, as with many things in our law, this goes back to the Middle Ages. The common law as regards citizens' arrest, in fact, originates with the Normans, who conquered the British Isles in 1066 and were the rulers of England for many years. The Norman kings instituted not just the right but the duty of citizens' arrest as a way of enlisting the citizens into helping keep the king's peace. And as I said, it wasn't just a privilege, it was a duty. An obligation was placed on the citizens of England to apprehend all felons, and held the citizens collectively responsible for doing this. Over time, this has changed to be merely a privilege or a defense. Just as a side note, I find it very interesting. Often when people think of the Middle Ages, or what we hear about the Middle Ages, is that this was this awful, tyrannical time, that the kings all ruled people with an iron fist, but in fact, when you look at a lot of things, and this goes as well to self-defense and other things that I've mentioned that harken back to the Middle Ages, medieval culture and medieval monarchy was in fact in many respects more democratic than our society today, as the citizenry and society at large were expected to take part in things that are now solely the purview of the state. So, going to the law as it is today, the criminal code has really superseded the common law. So let's look at the pertinent sections of the criminal code and what it lays out in terms of a citizen's arrest. Section 429 of the Criminal Code of Canada lays out the powers for a warrantless arrest by any person. So this governs not just citizens' arrests, but warrantless arrests made by police. So it indicates that anyone may arrest without warrant A, a person whom he finds committing an indictable offense, or B, a person who, on reasonable grounds, he believes 1, has committed a criminal offense, and 2, is escaping from and freshly pursued by persons who have lawful authority to arrest that person. Subsection 2 also allows for arrest by an owner of property, saying that the owner or a person in lawful possession of a property or a person authorized by the owner may arrest a person without warrant if they find them committing a criminal offense or on or in relation to that property, and A, they make the arrest at that time, or B, they make the arrest within a reasonable time after the offense is committed, and they believe on reasonable grounds that it is not feasible in the circumstances for a peace officer to make the arrest. Firstly, let's look at section 494 sub 1. Under that, subsection A allows anyone to arrest a person who they find in the act of committing an indictable offense. Just to explain quickly what indictable offense means, in Canadian law we have 2 levels of offenses, indictable and summary. There's some offenses that are strictly indictable, they can only be preceded by indictment, and some that are straight summary. Most are a hybrid, meaning that the Crown Attorney has the option to prosecute by either indictment or by summary proceedings. Indictment and summary proceedings are roughly analogous to the American felonies and misdemeanors. Indictable are the more serious charges that carry more serious penalties and also give an accused person the right to a trial by jury. Summary proceedings, on the other hand, is less serious matters that are meant to be dealt with in a quick or summary fashion, and you only have the right to trial by a judge alone at Ontario Court of Justice or the provincial court in the area you live. To arrest a person found committing has 2 requirements. First of all, the citizen making the arrest must have observed with their own eyes the crime being committed. And 2, the arrest must be made contemporaneously or at the same time as the crime was occurring or was observed. Thirdly, there must be in existence objectively reasonable grounds to believe that the offense had occurred. So that means that a reasonable person standing back and looking at what was going on, that they would have believed that there are reasonable grounds to believe that an offense had occurred based on what was observed. Now, there's some conflicting case law as to whether the offense needs to have actually occurred or whether the citizen only needed to have a reasonable belief that it occurred. I'm going to focus on the Ontario law because that's where I practice, and in Ontario, the Ontario Court of Appeal has ruled that the offense needs to have actually occurred. And the leading case on that is Gentles versus Toronto, 2010 ONCA 797. And that case said that it is not enough for there to be reasonable and probable grounds to believe that the offense occurred. It must be established that the arrested person actually committed the offense. Now, I stress that that's a big difference between citizens making arrest and police making arrest, because police powers under the common law allow them to make an arrest simply where they have reasonable and probable grounds to believe that the offense occurred. It is not required for police that the offense actually occurred. Now, subsection B of section 494 allows for an arrest on any criminal offense, so that could be indictable or summary, and it requires only reasonable probable grounds. However, there's that additional requirement under subsection 2 that the person being arrested is escaping from and actively being pursued by lawful authorities. So subsection B is really only an allowance to assist the police in making an arrest, not truly a citizen's arrest. So really 494 sub 1 sub A is the key section for a citizen's arrest. Subsection 2 does allow for a bit more broader powers if you're on your own property and defending your property by way of arresting someone who's committing an offense on that property. This section is most often used by loss prevention officers at Walmart or Costco or what have you. I not infrequently see individuals who are shocked when a loss prevention officer arrests them and are saying, well, you're not a police officer, you're not allowed to arrest me. Clearly, the criminal code allows owners or people authorized by the owner to make an arrest when they find someone committing a criminal offense. So if they see them shoplifting, they can make that arrest. Now, it's very important to keep in mind further requirements, and these are on both police and private citizens when making an arrest, and that's the extent of allowable force that can be used. And that force is constrained by the principles of proportionality, necessity, and reasonableness. This is very similar to the self-defense law. Those principles are at play there as well, and I encourage you to go back to look at my two-part series on Canada's self-defense law for more detail on this. The bottom line is you can only use as much force as necessary. In being proportionate, you can't, if someone takes a swing at you, that doesn't allow you to pull out a gun and shoot them. It has to be somewhat similar to the force that's being used against you. A number of cases have discussed what's required, and here's a non-exhaustive list of factors that have been considered by courts in determining whether a citizen's arrest and the force used in executing that is reasonable, proportionate, and necessary. So the courts will look at the nature and seriousness of the offense. So there's going to be a bit of a different consideration if you're trying to stop someone who's trying to murder someone versus trying to stop someone that was spray painting a fence. The courts will consider the level of certainty that the offense actually occurred. They'll look at the suspect's behavior, whether they were fighting back, whether they were being threatening in any way. They'll look at whether the public or the person making the arrest were put in harm's way or endangered by the manner in which the arrest occurred. They'll look at whether the suspect was armed, look at the background, whether there was belief that weapons may have been present, the arresting person's level of knowledge and experience, and the possibility of whether there'd be escalation. I think the bottom line to keep in mind here is this is a pretty complex, and there's going to be a lot of considerations going into this. As such, as a general rule, my advice is don't try playing cop. Leave policing to the police, and avoid making a citizen's arrest if you possibly can. These provisions are really only there so that you can prevent danger to someone else, and really then you're in a self-defense or a defensive third-person scenario, so you have those additional protections. I frankly just think it's playing with fire a bit to be taking upon oneself the duties of police officers given this current state of the law. Of course, this video is not legal advice. If you need legal advice, always call a lawyer. You can call another lawyer or myself. My 1-855 number and my website are listed below. If there's any topics you'd like to see me cover, please leave a comment in the comment section below or email me. And if you found this video interesting or informative, please consider liking, sharing, and subscribing or following me on social media.